Hello, everyone, and welcome to the Good Lawyer Gone Bad podcast. My name is Stuart Teicher. I don't think a lot of people understand what's been going on at the International Criminal Court recently. I don't think a lot of people really understand what the ICC is, and I don't think a lot of people understand the unique wrinkle that just occurred last week that could be a potential good lawyer gone bad. To understand the bad lawyer behavior in today's program, we need to travel to Europe and talk about the International Criminal Court. But we can't just talk about the court. We need to talk about the origins of the court. And I know what you're thinking. You're thinking, gee, Stuart, how can you possibly make a discussion about something as significantly boring as an international tribunal even more boring? You make it a history of that tribunal. My friends, I'm going to surprise you, because the story is actually a lot more interesting than you think. Don't believe me? Well, let's start in a place that is chaotic and scary. Let's go to the battlefield. Imagine that you're a corporal in the army. You're having a conversation with your captain and a colleague of yours who's a private. The three of you had just returned from a particularly difficult firefight. You lost 2 men in the skirmish, and everyone is on edge. Your friend, the private, says to you and the captain, "I can't take this anymore. I'm going to desert this unit. One of these days, I'm just going to take off running, and you're never going to be able to catch me." Your captain became visibly angry by the statement. He stares deep into your colleague's eyes and warns, "You be careful, soldier. If you desert, military law lets me shoot you, and I will." You're shocked by the statement. You know that military law doesn't allow that sort of vigilante justice in modern times. You chime in, "Captain, I don't think you can do that anymore." "Shut your ass, Corporal," he snaps back at you. "This is my unit, and I'll run it as I see fit." You step back, startled, and shut your mouth as your captain requested. Later that evening, you and the private are standing around a table reviewing some maps when he looks at you and says, "That's it. I can't take this anymore. I'm out of here." He turns away from you and starts to run off into the distance. Your captain, who's standing a few paces away, shouts at the private, "Get your ass back here!" The private continues to run. The captain reaches to his waistband searching for his pistol, but realizes his holster is empty. He looks at you and shouts, "Corporal, shoot that man!" You freeze. Your captain repeats himself, this time with even more anger in his voice, "Corporal, I order you to shoot that man!" You reach for your pistol, remove it from the holster. You stare at the private in the distance. You look back at your captain. He's glaring at you and he shouts, "That was a direct order! Shoot that man!" It was indeed a direct order. He is indeed your superior. So, what do you do? There are rules to war. Well, today there are rules to war, but it wasn't always like that. Actually, that's also not completely accurate. The powers of the world have been talking about the rules of war for ages. But for much of history, the rules of war were scattered, unclear, and confusing. And one of the issues in war that's caused considerable confusion throughout the years is the question of whether a junior soldier needs to listen to the unlawful orders from a superior. It's an incredible ethical quandary. What if you do what you're told? Well, then you followed orders, and that's good. That's what a soldier is supposed to do. But what if that order was an unlawful order? Are you supposed to figure that out? Or are you just supposed to listen to your superior? If it is unlawful, then don't you bear some individual responsibility for acting unlawfully? Or can you absolve yourself of personal responsibility because you acted at the behest of your superior? Should an individual act as an unthinking instrumentality of the state, relieved of his normal obligation to exercise individual thought and make appropriate moral decisions? Or is an individual responsible for his own conduct when he acts on the orders of his superiors. The issue has been debated for centuries. By the time World War I came around, military law throughout the world seemed to reach a consensus. Soldiers should listen to their orders. If they do that, then they're in the clear, even if the order is unlawful. Wow. Sounds there like they're saying soldiers are drones. Well, that was the rule. During the continuing legal education seminars I teach to lawyers, I've always told them about what I believe to be an unfortunate reality when it comes to the law. That is, society is relatively reluctant to change that law. There are usually one of two things that have to occur to push us to make change. It's either a massive scandal or a massive moment of history. So it shouldn't be too surprising that things changed during the massive moment of history that was World War II. The U.S. entered World War II in 1941, and it didn't take long for us to notice that the Germans were engaged in some pretty bad stuff. By 1942, Americans were increasingly aware that the Nazi regime was perpetrating the mass murder of European Jews. The American press was carrying news reports of the genocide, and in November of 1942 there were reports that as many as 2 million Jews were already murdered. When the dust settled after the war, the world's militaries were in shock. War had always been hell. War had always been messy. There was always a lot of death in war. But the scope of the Nazi atrocities, they were unthinkable. You have to put yourself in the shoes of the world's military leaders in the mid-1940s to understand the depth of their shock. We, in the year 2024, we've seen photos of the concentration camps many times. We've been educated about the Holocaust throughout all of our schooling. It's been part of the curriculum we study. And as a result, and to some extent, we've become desensitized to the horror. Not that it doesn't impact us, but we've seen these images before. Imagine, however, what it must have been like to see those photos for the first time just after the war in the mid-1940s. Never before had there been such a detailed record of such a massive genocide. Never before had there been an ethnic cleansing carried out with heartless precision and memorialized. Soldiers and civilians alike were beside themselves. The idea that military officers could order such horrifying treatment of other human beings was incredible. The world agreed that the military officers who orchestrated the Nazi death camps needed to answer for their crimes against humanity. And they weren't the only people that needed to be held to account. What about their subordinates who carried out those inhumane orders? Those Nazi officers didn't do the shooting and the burning and the killing themselves. Their subordinates listened to those orders and they carried out the atrocities. The idea that junior officers would acquiesce to something so horrible that they would follow those horrifying orders, it was equally appalling. I mean, their superiors weren't asking them to steal some supplies or lie about some bravery to earn a phony commendation. They were told to execute people, to engage in mass murder. And those junior soldiers did it. And they did it over and over and over again. Where was their conscience? Where was the morality? How could they not say something? Should they have done something? Well, if you consider the established law up till that time, the answer is no. They were mindless drones. The fact that they listened to their superiors was an absolute defense. In fact, it was called the defense of superior orders. Well, that was about to change. And the place that the change was going to happen was a small German town called Nuremberg. After the war, the world faced a question. How were they going to deal with these monsters? The officers and their subordinates. What should be done with them? Well, there was a clear answer from most of the world. Most of the world thought you should do with them what you had always done with this sort of vermin in the aftermath of a war. Execute them all. That's what was done throughout history. If they were disciplined at all, which they weren't always, it was done very differently than today. Swift, public execution was the preferred way of dealing with war criminals up until that point. So there was a heck of a good argument that they should just string up those Nazis, do it quickly, and make sure the entire world sees it. Okay, so let's say there was consensus on that point. Public execution is the way we're going to go. But that brings up another question. Who was we? Who would carry out that sentence? Who is doing the executing? What normally happened in post-war situations is that the war criminals were dealt with by their home countries. The country where those war criminals came from would conduct those summary executions. Quick, hasty judgments were issued, and fast, public, violent executions were ordered. But this war was different. World War II was one of those massive moments of history I was talking about earlier. This war would cause change. For it was in the wake of World War II that the powers of the world decided that it was time to take a big step towards the development of international law. International law is sort of garbage. Okay, maybe I'm being harsh. I don't mean that it's garbage. I just mean that it's sort of a strange bird. It's tough to even really call it law. When you pass a law in a country, you have an entire apparatus to give that law teeth. You've got a legislature, police, courts, prosecutor, jails. It's all there. But in international law, who makes the law? Who enforces that law? And how do you enforce it when you're talking about enforcing it against different countries, sovereign nations? Think about it. When a country doesn't want to listen to some international law, what do? They just don't listen to it. What does the world do if a country doesn't want to listen to an international law? There are only two ways to get a country to comply. One is to force them. That is war. And that's sort of exactly the thing that international law is trying to avoid. The other way to get countries to comply with international law is if they voluntarily agree to do so. They have to consent to follow it. International law is wholly dependent upon voluntary state consent. And that is what makes it a strange bird. So what was the big change after World War II? It was a crazy idea. The world could do like it always did and go with summary executions of the war criminals in the countries that they came from. Or there could be an alternative. What if the countries of the world came together and created a tribunal? And here comes the crazy part. What if they created a tribunal and gave the Germans a fair trial? Unheard of at the time. The idea of a fair public trial for genocidal maniacs might seem like an obvious approach today, but it was a paradigm-shifting idea in 1945. It was a massive change to the rules of the game, and the world collectively decided to go for it. They would embark on an historical experiment. A fair trial for war criminals conducted by an international tribunal. The place that they decided to hold that tribunal would be in the country where the atrocities occurred, but the people running that tribunal would be the countries of the world. The task of creating the first international tribunal for the trial of war criminals was taken up by a member of the United States Supreme Court. Justice Robert H. Jackson took leave from his duties on the court to chair a revolutionary moment in both world history and the law. And his approach would be revolutionary as well. In creating the legal standard that would be applied at Nuremberg, Justice Jackson decided to focus on individual responsibility. The focus would be on the individual, not the state. The idea was that in war, people make personal decisions about how they will behave. And those personal decisions have consequences. And that theory is why the tribunal would not only deal with the leaders of the Nazi war machine, but also their underlings. Junior Nazi officers would have to answer for their sins at Nuremberg. Justice Jackson's new standard differed greatly from the previous law. Those junior Nazi officers would not be able to rely on the defense of superior orders. They can't rely on the idea that they were simply ordered to act by their superiors. They would face the music for their moral failures and answer for their refusal to stand up in the face of the German atrocities. They would feel the world's wrath just as their superiors would in front of the tribunal at Nuremberg. The entire effort was so groundbreaking, and it was illustrated by Professor Henry T. King, Jr., who described the start of the trials in a now famous speech. He said, "As dawn broke over the Nuremberg courthouse on November 21st, 1945, the world little knew the significance of what was to occur that day. For it was on that day in Nuremberg that Justice Robert H. Jackson, speaking for the prosecution, would launch the first international trial of major war criminals in human history. For thousands of years up until that date, those who committed war crimes of the nature described at Nuremberg had largely gone unpunished. Now, at Nuremberg, civilization was coming to grips with the need to punish those who committed those crimes. As Jackson said in his ever-memorable opening address, the real complaining party in this trial is civilization. The method used at Nuremberg, a fair trial, was unparalleled in human history and unique in its approach. The Nuremberg tribunal would try those junior soldiers along with the most cruel and ruthless killers the world had ever seen. If you ever have a chance to travel to Nuremberg, you should go see the courtroom where all of this occurred. It's still there. It actually still operates as a functioning courtroom, but they do allow visitors to come see it at certain times. I saw it. It was very moving. Nuremberg was seen as a great step forward for international law. Over the next years, the world built on the momentum of that tribunal. International cooperation became a thing, and consistent with this new idea, the United Nations was founded in 1945 to help create a forum where the countries of the world could work together. On the criminal enforcement side, the world continued to enforce war crimes in the spirit of the Nuremberg trials. There were tribunals addressing atrocities in the former Yugoslavia and also Rwanda, for instance. But those tribunals were all created on the fly. They popped up after wars occurred here and there. The world believed, however, that they needed something more permanent. They needed an international criminal court of some kind. So, in the 1980s, the world decided to create one. An international body is created by international law, so in the 1980s, the world started to negotiate a law that would create an international criminal tribunal. Since the people hammering out the details of that law happened to be in Italy while they were doing it, they called the law the Rome Statute. The negotiation of the Rome Statute took some time, but finally in 1998, the International Criminal Court was born. It began operations in 2002. The ICC is the first permanent international criminal tribunal that the world has ever seen, and it owes its existence to the Nuremberg trials. The entire existence of the ICC was a direct result of the trials of the perpetrators of the Holocaust after World War II. The International Criminal Court exists today because of the attempted ethnic cleansing of the Jews. The modern ICC has a clear mandate. Its job is to adjudicate what are considered core crimes: genocide, war crimes, crimes against humanity, and crimes of aggression. Unlike other international bodies, it does not go after states, it prosecutes individuals. And that's exactly the spirit of Judge Jackson's ideas in Nuremberg. The ICC is not seeking state accountability, it's seeking individual accountability. The ICC is located in The Hague. The Hague is a city in the Netherlands, and yes, it's called The Hague, but it's just a city with a funky name. It's an old European city with a lot of history. The city began as a playground for royals. The name of the municipality comes from a hunting lodge used by the Counts of Holland, which was located in a woodland area called the Hedge. Count William II built a castle there in 1248, and in 1350 they dug the artificial lake you can still find in the center of town called the Hafeveren. The Counts of Hilland made the place their principal residence, building their homes in the area known as the Binnenhof, or Inner Courtyard, which is located in the old quarter of the city today. The city grew from there. According to Britannica, in the 17th century, when the Dutch Republic played a leading role in Europe, The Hague became a center of diplomatic negotiation. Years later, countries would come together in the city to create what was basically the first treaty regarding the laws of war. The Hague reputation was then solidified as a permanent center for international law. It was only natural then that the international community would gravitate toward The Hague when it was looking for a home for the International Criminal Court. The establishment of the ICC in The Hague should have been the beginning of a wonderful chapter in international law. But the ICC is not as universally adopted as the war crime tribunals that came before it. Yes, there are over 120 member states in the ICC, but there are two notable exceptions: the United States and Israel. Why? Why have these two countries refused to join the ICC? What about the United States? Not only isn't it a party to the ICC, but the U.S. isn't a party to other similar international organizations. And the reason the U.S. doesn't join organizations like that is a simple one: jealousy. The United States does not like to grant jurisdiction over its citizens to foreign or international powers because the U.S. knows that we have a lot of jealous, irrational enemies out there. There are a ton of people who resent us just for being us, and we know that they would love to take harsh action against U.S. citizens if they were given the chance. So we don't sign on to things like the International Criminal Court because it gives people an opportunity to do just that. This has been an approach that's been approved and pursued by both parties on the political spectrum. In fact, there was actually a law in the U.S. that's commonly referred to as the Hague Invasion Act. Passed in 2002, the law authorizes the use of military force to liberate an American or citizen of someone from a U.S. allied country who is being held by the International Criminal Court. As for Israel, why didn't they sign the Rome Statute? Well, a lot has happened in the world since the Nuremberg trials. And in some parts of Europe and the Middle East, the sympathy for the Jews has been replaced with anger. There's been a marked increase in anti-Israel sentiment throughout Europe and the Middle East since the 1967 war. That was the year that Israel captured the area known as the West Bank, East Jerusalem, and Gaza. Many nations in the world believe that Israel is illegally occupying those areas and that they're persecuting the Arabs who live there. The bottom line is that Israel was afraid that the ICC would be politicized and that the court would be used against them to prosecute what's happening in the West Bank and Gaza. Was that an irrational fear? Well, according to an article in the University of Georgia Law School's Journal of International Law, during the negotiation of the drafting of the Rome Statute, one proposed regulation would have made it a crime for Jews to live in the West Bank. So, as far as Israel was concerned, the writing was on the wall. Israel, whether you agree with it or not, felt that they would be a target for the ICC. Many people throughout the world have been very upset with Israel's actions in the West Bank and Gaza. As a result, they've tried to use international tribunals like the ICC to bring Israel to justice. Whether you agree with that or not is not the purpose of this conversation today. But I think we can all agree that Israel is the subject of a lot of international attention. The ICC thinks that it's warranted, and as a result, they've tried to prosecute Israelis for the actions that they think are inappropriate in the West Bank, Gaza, and East Jerusalem. The problem was they weren't able to do that. They had no jurisdiction. Israel refused to be a party to the court, so they couldn't go after their leaders. And Palestine was not recognized by the world as an independent state, so the ICC had no jurisdiction in the territories either. Well, things changed in 2012. In 2012, Palestine was granted observer status in the United Nations. Once that happened, the ICC considered Palestine to be elevated in status such that it was now eligible for participation in the court. Israel, of course, opposed the status of Palestine in the ICC, and so did the United States. The official United States position was set forth in a State Department press release, which states, "The Palestinians do not qualify as a sovereign state, and therefore are not qualified to obtain membership as a state in, participate as a state in, or delegate jurisdiction to the ICC." The ICC did not agree. They believed that Palestine was eligible, and in January of 2015, the government of Palestine accepted jurisdiction of the ICC. According to its rules, the ICC could now begin to look into the goings-on in Gaza, the West Bank, and East Jerusalem. So in 2015, they started a preliminary investigation into what they called the situation in Palestine. The Israelis took an interesting approach. Instead of sitting things out and refusing to cooperate with the ICC, they tried to engage. Israel tried to convince the ICC that there was no basis for any charges to come from their investigation. But instead of getting the ICC to drop the matter, the intensity was kicked up several notches in 2021 when the ICC changed the preliminary investigation to a formal one. The last 20 years have not been easy for the ICC. It's been incredibly controversial, and the issues aren't just about Israel, and its critics are not limited to the United States and Israel. In 2020, a hugely critical report was issued about the institution. It seems that people didn't think the court was delivering enough bang for the buck. The report found that the court burned through about $2 billion in funding, but delivered less than 10 convictions. And there was additional criticism about those convictions, because almost all of them targeted individuals from African countries. The ICC desperately needed to improve its brand. And there was a chance for that in June of 2021 when the chief prosecutor was up for election. Maybe they could replace the prosecutor with a charismatic, well-respected international lawyer who could be a great face of the institution. Enter Karim Khan. The United Kingdom put forth one of their own citizens as a candidate for the prosecutor's job at the ICC, Karim Khan. Mr. Khan is a British lawyer. Born in Edinburgh to parents of Pakistani descent, Khan was brought up in the UK and educated in its finest institutions. He is married to his second wife, and he has 2 children. Khan's career seems tailor-made for the International Criminal Court. He specialized in international criminal law and international human rights law. Between 1997 and 1998, Khan worked as a legal officer at the Office of the Prosecutor at the International Criminal Tribunal for the former Yugoslavia, and he later served as legal advisor at the Office of the Prosecutor at the International Criminal Tribunal for Rwanda. He was a seemingly perfect choice to head up the prosecutor's office at the ICC. After multiple rounds of voting, Karim Khan was elected as the 3rd prosecutor in the history of the ICC. He's serving a 9-year term. Khan has been struggling to refresh the ICC's image, and in October of 2023, he got what must have seemed like a golden opportunity. Hamas invaded Israel on October 7th. In the ensuing months, Israel responded with deadly force, killing Hamas combatants and civilians alike. Many in the international community believe that both sides committed war crimes. It was a tragedy for the world, but an opportunity for the ICC. This was Karim Khan's chance to make the International Criminal Court relevant. The institution's brand had been pummeled recently, and the war between Israel and Hamas gave him an opportunity to rehabilitate the court's image. He could score points in a couple of ways. First, if he filed charges against both the leaders of Israel and the leaders of Hamas, he would appear to be an impartial bastion of legal principle, an even-handed dispenser of international law. Second, charging Israel, a Western democracy, would score a ton of points with the countries who resented Western power. And third, there were many countries who believed that Israel had killed civilians indiscriminately and needed to be brought up on charges at the ICC. If Karim Khan played his cards right, he could establish worldwide credibility for the ICC and for himself as its leader. So here was the plan. Khan would file applications for arrest warrants for both Israeli leaders and Hamas leaders. Now, we have to talk about that for a minute because the technicalities matter. Here's how it all works. When the ICC prosecutor wants to go after an individual, he has to ask the court to arrest those people. He has to apply for arrest warrants. He makes that application to a group of 3 ICC judges who determine if those warrants should be issued. It's important to understand that process. The prosecutor is not issuing arrest warrants. He's making an application to the court where he's asking for the court to issue those warrants. But there's something the prosecutor needs to prove in the application for that arrest warrant, and that issue is at the heart of this situation. The Rome Statute made it clear that the International Criminal Court was a court of last resort. The only time the court is allowed to go after offenders is if the offender's home country is either not willing or not able to do so on their own. If the home country has a functioning legal system that's able and willing to prosecute the offenders, then the ICC has no authority to move against those individuals. In other words, the ICC is complementary to the home court. That phrase, complementary, is key. Sometimes it's referred to as complementarity. If the war criminal's home country has a functioning legal system, then the ICC has to sit by and do nothing. So, what was Khan going to do in this particular instance? He was going to seek arrest warrants for 3 Palestinians: Yahya Sinwar, the head of Hamas; Mohammed Deif, the commander-in-chief of the military wing of Hamas; and Ismail Haniyeh, the head of Hamas's political bureau. He was going to go after them for war crimes of rape, murder, and kidnapping committed in Israel during the October 7th invasion. Khan didn't have any problems establishing jurisdiction there because the Palestinians had signed off on ICC jurisdiction back in 2012. And they didn't have a functioning court system, so that factor was satisfied. He would also charge Prime Minister Benjamin Netanyahu and Yoav Gallant, the Minister of Defense of Israel, for war crimes committed in Gaza. Specifically, he claimed that those 2 men were responsible for the starvation of civilians as a method of warfare, and that was a war crime contrary to the Rome Statute. Now, you might be wondering why Khan chose the starvation charges. Well, remember, the ICC goes after individuals, not governments. So the prosecutor needed to find a link between the individual leaders and the criminal violations. They believed they did that with the starvation angle because there were public statements made by those officials, and the ICC considered that those statements illustrated that the individuals pursued a policy that was purposefully designed to starve the Palestinians. But Khan couldn't just file the applications for the arrest warrants. He had to prove that he had jurisdiction over the Israelis. Well, the alleged bad actions happened in Gaza, which was subject to the ICC jurisdiction, so he had that part satisfied. But what about that whole complementarity thing? Well, that's where things get a little thorny. Israel actually has a vibrant, critical criminal justice system. They have a court that deals with criminal and constitutional issues all the time. But was that court willing to pursue charges against its own leaders if the charges proved to be valid? Well, the only way for the ICC to know is to ask. And actually, that's exactly what the ICC rules require. Because the ICC can only move in when there's no functioning legal system in the home state, a fundamental principle in the ICC Charter is that it gives the country in its crosshairs the opportunity to investigate the matters before the ICC takes action. The prosecutor has to give notice to the target country. The Rome Statute requires that prosecutors provide sufficiently specific information to the state under investigation about the crimes that they are investigating, and that's because they want to give the country the ability to inform the court that it's willing to carry out such investigations and prosecute the offending individuals when necessary. If the country gives that confirmation, then they have the courts willing to take action, and the ICC doesn't have jurisdiction. So, what Karim Khan was going to do was make applications for arrest warrants for all the people in his crosshairs, but of course he had to comply with the Rome Statute first. And that's where things get a little curious. Karim Khan was scheduled to go to Israel on May 20th, 2024. The meetings, presumably, would be to discuss his office's investigation. Maybe he would give them the notice required by the Rome Statute at that time. We don't know. The reason we don't know is because instead of showing up and talking to Israel, he canceled the meeting at the last minute and instead announced that he was seeking the warrants that very day. Israel was shocked. They insisted that Khan reneged on his obligation to notify Israel properly and give them a chance to prove the viability of their legal institutions. Khan had a counter-argument. He said Israel already got its notice. He and his legal team put together a significant legal argument that they believe supported the idea that the Rome Statute notice was actually complied with. They say that Israel got the warnings by virtue of the interactions the ICC had with Israel over the past few years. For what it's worth, the Israelis were not the only ones surprised. President Biden's administration says that it was blindsided by the move. What happened next was, to some extent, exactly what you would expect. A whole host of people started to criticize the prosecutor. A whole host of people came to the prosecutor's side as well. A ton of people, a ton of lawyers, believe that the application for warrants filed by the prosecutor are legally valid and supported by significant law. Well, not everybody agreed. And not only did those critics attack the prosecutor, but they began to question the integrity of the ICC as a whole. Critics claim that Karim Khan's actions threatened the legitimacy of the institution of the International Criminal Court. So what did Karim Khan do in response to that criticism? Well, something that maybe you wouldn't necessarily expect. He threatened dissenting voices with criminal prosecution. Yeah, he said that anyone who criticizes or tries to block the prosecutions of the court was going to be charged under Article 70 of the Rome Statute, which means that anyone who spoke up against him would be prosecuted. Here is the question. The question is, why push so hard? Why take extraordinary measures to silence the critics? Why move against Israel without having that meeting? Why cancel that meeting? Okay, you can make the argument that you gave notice properly in other ways. You were supposed to go meet Israel that day. You could have given the notice specifically and there wouldn't be any kind of issue. Why cancel a meeting and rush to file the applications for the arrest warrants that very day? The reason given by Prosecutor Khan was that the circumstances demanded it. If war crimes were going on, people were dying, and they needed to take action boldly and quickly. But this week, something was revealed that might provide another explanation for why Karim Khan moved so quickly that week in May of 2024. If you believe the press reports from last week, there was a lady involved. The Hague has got to be a pretty cool place to work. The city is located in the Netherlands, about a 50-minute train ride from Amsterdam. I know that because I went there recently to go see the building where the ICC lives. The ICC resides in a grand facility that's called Peace Palace. It's a beautiful structure that was built in 1913 with an endowment from American industrialist Andrew Carnegie. The building is stunning. The city is interesting too. It simply drips with classic European charm. So getting to work in the ICC has got to be a pretty plum gig. And I'm sure that's what one of the female staffers at the ICC thought when she got the job. Well, she probably thought that until recently. The following facts are from the Associated Press as reported by CBS News. According to allegations made public last week, the female staffer, who I'll refer to as Mary, she kept her identity anonymous, Mary worked at the International Criminal Court. And Mary must have been thrilled with her good fortune because she was getting a promotion. Mary was being transferred to the prestigious office of the prosecutor of the ICC, and she was getting an increase in pay. What she didn't know is that the move appears to have been orchestrated by the prosecutor himself. It's alleged that Karim Khan noticed Mary working in another department and had her transferred to his office. It seems that the prosecutor was not only interested in working with Mary, they began to spend time together outside of work. They would have dinners together. During one of those dinners, Khan allegedly crossed the line. While complaining to Mary about the poor state of his marriage, reports say that Khan reached across the table and took Mary's hand. Khan's pursuit of Mary seems to have intensified. Allegations are that he pursued her inside and outside the office. Those reports claim that at one point he allegedly locked the door to his office and stuck his hands in her pocket. At other times, he apparently tried to convince her to go on vacation with him. The time they spent together both in and out of the office also seems to have created something of a connection with Khan. The prosecutor started keeping Mary close more often. She began to accompany him on official trips and meetings with dignitaries. Then, on one trip, Khan allegedly invited Mary to a hotel room. He allegedly asked the woman to rest with him on the hotel room bed and then sexually touched her. That apparently did not end well, because the Associated Press reports that Khan was later found outside Mary's hotel room at 3 o'clock in the morning, knocking on her door for about 10 minutes. That alleged harassment was claimed to have gone on for over a year. Well, at some point, Mary couldn't take it anymore. After returning from one of their trips, she opened up to friends back at ICC headquarters, and it seemed this all came to light when two of those co-workers reported it. When the allegations were brought to the ICC's attention, the matter was given to their independent watchdog unit. But Mary didn't get a good feeling from them. Investigators from the department showed up at Mary's home on a Sunday. They pressed Mary for intimate details about her relationship with Khan and then pried into those sensitive matters while her children were there listening. She claims the investigatory agency gave her no emotional support whatsoever, and as a result, she became wary of the entire process. Mary refused to file formal charges. People close to her say that she refused to press the matter further because she didn't trust the group who was investigating. Maybe her distrust of the investigators was warranted, given that Khan was never even questioned. The matter was closed 5 days later. All of this was leaked last week. When it came out, Prosecutor Khan categorically denied it all. Some in the ICC have even claimed that this could be part of an elaborate setup. Khan, they say, has a stellar record of pursuing war crimes, and the targets of his prosecutions have reason to want to bring him down. Some court officials believe that the allegation are even part of an Israeli attempt to smear the office that's pursuing them. Well, we're going to find out, because the matter isn't finished. Mary, you see, didn't give up. Shortly after the ICC watchdog closed the case, Mary went over their heads. She reported the matter to the organization that oversees the ICC and controls Karim Khan's fate, and asked them to launch an external investigation. So how does this tie into the issue with the arrest warrants in the Israeli-Hamas matter? Well, consider the timing. Do you know when Mary's friends reported the alleged conduct? Early May 2024. Do you remember when the applications for the arrest warrants were filed? Late May 2024. Those applications were the ones that were seemingly rushed through. Those applications were the ones that were filed on the very day when the prosecutor mysteriously canceled his trip to Israel. The trip where he was presumably going to notify them and investigate about the complementarity issue. You remember the move that blindsided the U.S. president? The applications for those arrest warrants were filed only days after the independent watchdog closed the case into Mary's allegations. A cynical person might wonder whether there was a link between the seemingly hasty actions of the prosecutor just before filing those applications and the allegations of misconduct that happened to have surfaced around the same time. Well, some cynical people are now calling for a review of the situation. They wonder whether the prosecutor rushed to file those charges, possibly to deflect from the allegations. Or maybe the prosecutor was worried that the allegations would get out and the publicity would force him to hold off on filing the applications altogether. Maybe that's why he canceled the meeting in Israel at the last minute and rushed the applications to the court. Hopefully these questions will be asked during the pending investigation, and we'll figure out whether there's any truth to that or not. The prosecutor, of course, is going to have a ton of legal arguments to support his position. They've already released it. They've got an army of lawyers who has set forth in great detail their justification for filing the warrant applications. Their legal positions are plausible, their legal positions are supported by decent arguments, and their legal positions could be defended. But this isn't just about law. It's politics too. And politics is about optics, and this all looks terrible. No matter what happens, one thing is clear. The attempted refurbishing of the ICC brand was a failure. The organization that was created out of the ashes of the Holocaust is now fighting for its own life. And only time will tell whether its prosecutor and even the institution itself will survive. Next week, we'll return to our standard type story for the Good Lawyers Gone Bad podcast. We'll talk about a true lawyer crime that the court considered to be the most egregious lawyer violation they had ever encountered. Speak with you then.